libreria dei podcast della Corte Costituzionale.
Like others, I would like to thank the Italian Constitutional Court and the other supreme Italian jurisdictions for the very warm welcome we have received here in Rome. It is no wonder that all roads lead to Rome with such hospitality. Thank you also, President Amato, for your succinct introduction of this second working session, and I will try to do it perhaps not quite as shortly, but to respect, insofar as possible, the time limits set. It's a rather delicate subject to introduce, I think, rule of law and judicial independence. Part of the job has been done notably by President Lenaerts, but also other speakers in the first session, because there is a certain overlap between the first subject and the subject of this afternoon session. I will do it. Give my observations on the basis also of my time, almost 17 years at the Court of Justice. Before that, 3 years as a judge at the Danish Supreme Court. My time is, as I hinted, not without limits, and I will first rather briefly introduce the basic legal framework in union law on rule of law and judicial independence, and then I will turn to the main fields where the principle of rule of law and the notion or principle of judicial independence has been interpreted and applied as illustrated by case law of our court. Finally, I will talk on the effects and consequences when these principles are not respected and judicial independence is not or no longer present, in particular due to a systemic or generalized deficiency in the judicial system of a member state. As already said, it's in Article 2 that we find a list of the fundamental values on which the European Union is founded. And among them, the rule of law is highlighted, and it's further stated that these values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. Now, why this article, in particular when we already have a declaration in the preamble stating that the member states confirm their attachment to the principles of liberty, democracy, and respect for human rights and fundamental freedoms, and of the rule of law. As explained well in the first section, it's because Article 2 is something more than a simple declaration. To be attached to something is one thing, but to be under a legal obligation is something different. And as it was also mentioned this morning, becoming and being a member state of the European Union is voluntary. It's an act of will of the member state, and as the United Kingdom has sadly demonstrated, a member state is free to leave with or without an exit agreement in accordance with Article 50 of the European Union Treaty, as confirmed by the Court of Justice in our Whiteman judgment. However, as long as you are a member state, you are obliged to respect the fundamental values listed in Article 2, including the rule of law. The concept of rule of law entails several elements, among which I will here highlight the judicial review of legislative and administrative action to ensure constitutionality of the legislation and the legality of administrative acts. Such controls presuppose judicial independence from the executive and legislative branches of government, essentially the basic separation of the three state powers that Montesquieu advocated more than 250 years ago. Surely, as I think Francesco Vigano argued, this can be done in a great many ways, and the treatise does not point to or give preference to a single specific shining path. We are also, in this respect, united in diversity. Nevertheless, the diversity is not without limits, as all the member states still have to respect the basic values. Then there is a further concretization of the principle of judicial independence flowing from Article 19, 1 second subparagraph of the European Union Treaty and from Article 47 of the Charter. Article 19, 1 second subparagraph obliges member states to provide remedies sufficient to ensure effective legal protection in the fields covered by union law. And as a side remark, the Court of Justice has confirmed that this part of this article has, in fact, direct effect. Article 47 of the Charter enshrines in primary EU law two fundamental rights, the right to a legal remedy and the right to a fair trial. Finally, I mentioned briefly Article 267. This article of the functional treaty is the cornerstone on which the preliminary reference system is based. The system that counts for approximately 75% of the caseload at the Court of Justice. And the right to make a preliminary reference on the interpretation of EU law and on the validity of EU law is a right that belongs to all national courts and tribunals in the member states. Normally it does not give rise to great doubts whether an order for reference arriving at the Court of Justice, be it from a court of first instance, an appeals court, or Supreme or Constitutional Court, is made by a court or tribunal of a member state, in the sense of Article 267. But occasionally the question does arise whether the body or board, which is not perhaps a classical court or tribunal, but something more hybrid, is in fact qualified to pose preliminary questions. And then among the many criteria that the court looks at is the independence of the court, is it established by law, and is the court or board without organizational and functional links to the administration, whose decision it is to oversee. Judicial independence has both an external and an internal aspect. The body and its individual members must be protected against external intervention and pressure, and internally, the members should act impartially in order to provide a level playing field for the parties in the procedures before the body. This necessitates rules on the composition of the body, on the qualifications and appointments of its members, their lengths of service, payment, and dismissal, as well as internal rules on issues such as voting, quorum, and abstention in case of conflicts of interest. In the case Juízes Portugueses, the Portuguese Union of Judges unsuccessfully challenged that a general cut of salaries due to the economic and financial crisis in Portugal had been extended to also affect the salaries of the members, judges of the Portuguese Court of Auditors. The key discussion in this case was not about admissibility, but on whether the independence of the judges concerned had been affected by the general cuts in salary. But in the court's judgment of 27th of February 2018, the court summed up the key elements of judicial independence and stressed that judicial independence is required by EU law not only for the judges and advocate generals at the union courts, but equally for national judges in the member states whenever they apply union law. It is also worth noting that the court in this judgment noted the link between Article 19, the Union Treaty, on the value of the rule of law and the principle of sincere or loyal cooperation expressed in Article 4.3 of the Union Treaty, thus stressing the responsibility of each member state to secure the required judicial independence of its national courts whenever they are applying union law. In the judgment of 24th of June 2019 concerning the independence of the Supreme Court of Poland, the Court of Justice essentially confirmed this case law on the definition of the notion of judicial independence. This makes a transition to the next part of my introduction, as I will now turn to the substance of the case concerning the Supreme Court of Poland. The Commission was in this case contesting the so-called judicial reform in Poland that combined a general lowering of the retirement age of Supreme Court judges from 70 to 65, leading to the removal of a significant number of judges, with the discretionary power of the Polish president to extend the employment period for selected judges for up to 2 times 3 years. The court in the judgment stated that the explanatory memorandum to the new Polish law contained information that raised, and I quote, serious doubts as to whether the reform of the retirement age of serving judges of the Polish Supreme Court was made in pursuance of potentially, I would say, legitimate objectives of harmonizing legislation on retirement age, and, quote again, not with the aim of sidelining a certain group of judges of that court, end of quote. The court further noted that the alleged purpose of harmonizing retirement age nationally had not been pursued with consequence, since the retirement age for most other groups on the labor market implied only the right, not the obligation to retire. The Court of Justice found that this judicial reform implied that Poland had failed to respect its obligations under Article 19, second subparagraph of the Union Treaty. Later, that same year, 5th November 2018, the court applied a similar reasoning concerning the Polish law that reduced the mandatory retirement age from 70 to 65 for men and 60 for women, and combined this with the possibility for the Minister for Justice to authorize for selected judges a continuation in judicial function after they had reached retirement age. The Court of Justice ruled that Poland was in breach of Article 19(1) TEU and Article 47 of the Charter. We have equally had several cases concerning appointment conditions and procedures brought to us during the last couple of years. In a preliminary ruling delivered on 19th November 2019, the Court of Justice raised doubts on the new appointment procedures for members of the disciplinary chamber of the Polish Supreme Court. This was in particular due to the involvement of the new and disputed National Judiciary Council, KRS, and the fact that sitting judges of the Supreme Court who had not been appointed with the involvement of KRS could not be appointed for the disciplinary chamber. The National Referring Court, which was the labor chamber of the Polish Supreme Court, on 5th December 2019 ruled that the disciplinary chamber is not a court within the meaning of Article 47 of the Charter, Article 6 of the European Convention for Human Rights, and Article 45, first paragraph of the Polish Constitution. In the Republika case, it was the Constitutional Court of Malta that referred questions on the procedure laid down in the Maltese Constitution, given the Prime Minister discretion to appoint members of the judiciary. In its judgment of 20 April 2021, the court did not find that the Maltese law was contrary to EU law and emphasized in this respect a number of important constitutional and institutional measures that circumscribe the Prime Minister's discretion. However, the court emphasized in its judgment the obligations to preserve the rule of law flowing from Article 2 and 19.1 of the Union Treaty. If we then turn our attention to the area of disciplinary and control procedures, we once again have to mention a case of Polish origin, Commission versus Poland, which was decided by our court on 15th of July 2021. The court found that Poland had failed to fulfill its obligations under Article 19.1 by inter alia failing to guarantee the independence and impartiality of the disciplinary chamber and by allowing the content of judicial decisions to be classified as a disciplinary offense. The court also found that Poland had violated Article 267 by making it possible to trigger disciplinary procedure against Polish judges who had used their right under Article 267 to make a preliminary reference to the Court of Justice. Romania is equally represented in our case law under this subheading. In the judgment, Romanian Judges Forum delivered in May 2021, the Court of Justice once again stressed the need for disciplinary chambers to be set up in such a way and in accordance with rules such as to safeguard the impartiality and independence of the chamber and its individual members. It is, said the court, and I quote, essential that the body competent to conduct investigations and bring disciplinary proceedings should act objectively and impartially in performance of its duties and to that end be free from any external influence, end of quote. As it is normal in a preliminary ruling case, it is then for the referring court to apply the EU law as interpreted by the court on the national law and the facts at hand in the national file. I now have a brief remark to make on the liability of judges. This was at stake also in the Romanian Judges Forum case, where the court drew a sharp line between state financial liability for judicial errors, which is certainly in conformity with Articles 2 and 19 of the Union Treaty, and personal liability of individual judges for damages caused by judicial errors they may have made, which on the other hand is not acceptable. Transfer of judges is also an issue that has been brought up in our jurisprudence, and they may set limits when read together with Article 19 TEU. The Court of Justice on 6th October 2021 rendered a judgment in the VZ case, which confirms this. However, the factual and procedural setting of this case is a rather complex one and intertwined with other preliminary references, so I will skip a further explanation of this judgment. I will then turn to the final part of my introduction, the possible general effects and consequences when the principles of rule of law and of judicial independence are not respected in a member state. I've already talked about the potential inadmissibility of preliminary references made by bodies who in the end may end up as not qualifying as a court or tribunal in the sense of Article 267. I will now talk a little about the possibility of more general consequences when these principles are not respected and judicial independence is not or no longer present in particular due to a systemic or generalized deficiency in the judicial system of a member state. It is also an issue which has been brought before the Court of Justice in several cases. In particular, when we turn to the European arrest warrant. It was first an Irish court, the case Minister for Justice and Equality, that confronted us with this issue. It was about a European arrest warrant concerning the surrender of a Polish citizen to Poland, and the referring court was, with reference to inter alia reports from the Venice Commission, concerned with the possible general deficiencies in the Polish judicial system. The referring court therefore asked whether the general violations of the principle of judicial independence in Poland following the judgments delivered by the Court of Justice implied that there was no longer a sufficient basis for the necessary mutual trust in order to execute the European arrest warrant at hand. And the Court of Justice, referring to the Arianosi and Calderaro judgment, stated that limitations may be placed on the principles of mutual recognition and mutual trust between member states in exceptional circumstances. The court also noted that not only the decision on executing a European arrest warrant, but also the decision on issuing such a warrant must be taken by a judicial authority that meets the requirements inherent in effective judicial protection, including the guarantee of independence. And the court continued to follow the reasoning of the Arianosi and Calderaro judgment and told the executing judicial authority to determine specifically and precisely whether, having regard to his personal situation as well as to the nature of the offense for which he is being prosecuted and the factual context that formed the basis of the European arrest warrant, and in the light of the information provided by the issuing member state, there are substantial grounds for believing that the wanted person will run such a risk if he is surrendered to that state. The essentially same question has come back to the court on references mostly from Dutch courts. The answers given so far have been in line with the answer in Minister for Justice and Equality, but we still have pending cases on these and similar issues, including some from Italian high courts. I believe it is fair to say that the Court of Justice, in particular when it comes to the framework decision on European arrest warrant, has given a certain priority to the principle of mutual recognition based on mutual trust. The Court has thus accepted that the EU legislator has set the bar quite high before a general or individual risk of breach of the principle of rule of law and judicial independence in the issuing member state obliges the executing member state to not execute a European arrest warrant. And it's finally important, I think, here to bear in mind that different from, say, the area of the Dublin regime, we are, when we talk about the framework decision on the European arrest warrant, confronted with a kind of what I call a Goldilocks dilemma or squeeze. Because of the legal technique chosen by the EU legislator, the administrator and the judicial authorities, they have, when identifying the borderline, they have to get it just right, hence the appearance of Goldilocks, when interpreting the framework decision. They must surrender the requested person unless a sufficiently qualified breach of fundamental rights exceptionally obliges them not to surrender. But they are, unlike in the Dublin area, not allowed to be more generous, to be on the safe side vis-à-vis fundamental rights. No, they have to get it just right, which is a challenge for you as it is for us.